legal rights. So if for some reason there is a problem with the account and the person who has online banking password and username needs to somehow do something on the account as a signer, they are not able to. The only thing they can do is access the account online. The last thing is there is a process now that was not in place when I first started 24 years ago. And that process that happened several years ago is it used to be that we were always waiting on a family member to come in with a death certificate in order for us to know that somebody had passed. Well, that is no longer the case. Now we oftentimes get death certificates from the coroner's offices. And that was set up that way specifically because of Social Security. So what happens in the case of people who receive Social Security, if they pass, the date of death is very important, and they prorate the last Social Security payment. And even if they've paid the whole payment, a chunk of that is owed back. And so what was happening is a lot of times the family was coming in and beating Social Security to the account, not on purpose, but they would close the account, and then Social Security would have to try and figure out how to get that chunk of money back that they were owed. So they came up with this solution that, okay, well, if the coroners alert the banks when somebody passes, well, they can freeze it and they can hold the Social Security money there until Social Security is ready for it. Because of that, if something happens to the primary on the account and you have access because your username and password has been working and then they pass, it will likely be frozen, the account. And once it's frozen, you have no more access. So, well, you would think, okay, if an individual account is a solution that isn't great at working, what about joint accounts? Uh-oh, I think we have a problem again. So joint accounts is the very next place we're going. That's right. There we go. All right. So this is going to be a presentation of stories. Let me tell you a story about a joint account problem. I once had somebody come into my office, and this was a woman, middle-aged, very previously upset. I could tell that she was coming into my office anticipating a problem. And what she shared with me that had happened is that her mother had passed, and that her mother had communicated with her that an account had been opened, and that all of the money in that account was supposed to be split amongst her and her three siblings. And so I pulled up the account, and then what I saw was that it was an individual, I'm sorry, it was a joint account between the mother and someone else. And this other party was her brother, who had been put on the account to help her with her financial needs when she was no longer able to handle her own finances. But the problem that had happened is there was a handshake agreement between mom and son to split up the account amongst the four siblings when she passed. And he was not doing so. And because he was not doing so, legally, there was nothing that could be done. Because in a joint account situation, it is jointly both people's accounts. Now, that is not the only reason why you wouldn't want to do something like this, but let's talk about why you might first. Joint account spouses? Yeah. So I don't, no, no, no. So yeah, in a joint situation, especially in the state of California, where it is a community property state, both people are, legally considered to be one party. There's nothing wrong with that. Although you may want to consider if something happens to both of you, what happens next. But so the benefits are it's very easy to set up. So in a situation where I want to add somebody as joint, I just bring them in, set them down, sign some papers, and we're done. Quick and easy access, quick and easy oversight, and it does provide continuity if a loved one becomes unable to handle their own finances, and that continuity continues after the passing of the primary. So if the person passes, the joint signer then becomes the individual account holder and continues to have access. That's great in a situation where you might need to pay a bunch of bills right after the passing of the primary. You might need to, pay pay for a house payment and pay the landscaper and all the funeral expenses that stack up. But the downside to this is because the account is legally considered belonging to all the account signers, if something happens while the primary is still alive, but it happens to the joint, it can affect the account still. So for instance, let's say that I'm on my dad's account and I'm bad and I haven't been paying my child support. And then they levy my accounts. Well, now because I'm on my dad's account, it's going to come out of dad's money too. So there's all sorts of reasons why a lawyer would never suggest to you to just add a joint signer on an account, because you never hear about it when it works, but when it doesn't work, oof, those are the stories. So the other thing is the first story that I told, beneficiary plans won't kick in unless every signer has passed. So if you add a bunch of beneficiaries on your account, but it's a joint account, if only one of you passes, the beneficiaries don't have any rights yet. It's only if both people pass. Okay? Speaking of beneficiaries, what good are beneficiaries adding to an account? Well, let's talk about that. So just like adding a joint signer, beneficiaries are easy to set up, and they will give you peace of mind that if something happens to you, that your next of kin will be able to step in and take over. It does make it very easy to wind the account down. If you've passed and their beneficiary is bringing in the death certificate, they just have to prove who they are and they get the money right there. It's done. Close the account, give them the check. It also allows, of course, for you to avoid the dreaded probate process, and we'll talk more about probate here in a minute. The challenges around a beneficiary is it doesn't allow any kind of rights before something happens to you. So let's say it's a situation where you're looking for help with your finances and the person is only a beneficiary. Well, they can't access the account unless you've passed. There's no rights for any other situation. There's another odd situation with beneficiaries that has been handled differently at every financial institution that I've been at. So let me throw a situation at you that a lot of people have not considered. Let's say me and my spouse are on an account and we have 4 individual beneficiaries. And then me and my spouse and one of those beneficiaries get into an accident together, all at the same time. Well, there's a circumstance where they have to figure out the order of who's passed at what moment so they can tell whose estate things belong to. Because if the beneficiary predeceases one of us, now how do they split up the money? Is it split up amongst 3 of them because the 4th beneficiary passed 10 minutes before the primary? Every financial institution I've worked at has handled that differently. I can tell you at Noble, we would actually present the facts to our attorney and have them make a determination of how to pay that money out. So beneficiaries can be a very inelegant solution, especially if you have a lot of assets and you're wanting to make sure that they get distributed appropriately. So a beneficiary is better than not having a beneficiary, but there are better solutions than having a beneficiary. So the other thing about beneficiaries is, let's say that something happens and they're trying to figure out what bills mom and dad were paying, and mom and dad have passed. And so, hey, I need to know what money's coming out of the account automatically and who do I need to pay? They don't get any of that information. Account is closed, you get a check, that's it, done. So no information on the account is able to be obtained. Power of attorney. So power of attorney partially addresses the problem with the joint signer. So remember the joint signer, one of the problems was, what if the person that you've added as a joint signer does something, there's a levy or there's some kind of financial problem and it's going to affect your account. Power of attorney means that the signers on the account are not owners. They can sign on your behalf. So you're giving away your ability to sign to someone else, and they can sign on your behalf, but they are not listed as an owner of the account. So if there's a levy on a power of attorney, it won't affect your account. Okay, well, that's good. The other thing is they're generally very quick and easy. If you bring generic power of attorney documents to a notary, you can have it done without going to a lawyer. It's possible. You can hop online and pull up power of attorney documents. Now, if you have, yeah, yeah. So there's various types of power of attorneys. The most common is a general power of attorney, and with that one, it's hey, as soon as you sign it, you got signing rights for somebody else's behalf. And yeah, if you do set up a power of attorney, and you would then just take it to the bank and register that power of attorney on the account, and that works. I, though, would recommend that if you're going power of attorney route, that you still talk to an attorney. And the reason that I recommend that is oftentimes a power of attorney is best built with a medical power of attorney at the same time. There is a full suite of planning that a lawyer will do for you so that you are covered not just for financial things, but also for medical things. And so if something happens to you and you're not able to make your own determination about what should happen with your own health, that's when a medical power of attorney would step in, and those are separate documents, but they're often done at the same time. So,
Can we
um,
ask question? Is it
yes, sir.
possible, or we should? Okay. So the situation that you describe, let's say, uh, let's say husband and wife,
Okay.
and one of the spouses, dies or pass away. Let's say if the husband passes away, and then the wife is really incapable of making any kind of decision while the husband was living,
Okay.
then now what does the beneficiary do when this situation take place, when the father is gone? Now the mom is really incapable of making any decision, but yet she is still alive. So
Yeah.
what sort of power does that beneficiary has in order to manage the finances?
Yeah. And that's a great question. And unfortunately, that does happen. So, one of the things that I didn't mention, but it was listed as a bullet point on the first slide, was that over time, oftentimes people lose options. And so, what I heard about the scenario you just shared with us is that the spouse, the wife, was not in a position to handle her own finances. Now, there's two different ways to define that. One is a knowledge gap, and the other is an actual medical reason. If it's just a knowledge gap, then there's still options. She can still go get a power of attorney and allow other people to sign on her behalf and help her make decisions. She can add people to the account. Basically, all of the options we're talking about today would still be available to her. But if it's a medical situation where she's not able to handle her own finances, I can tell you, I've been a notary for years as well. There's a test that we use. And what that test is, if we think we're helping somebody who may not be capable of handling their own finances, we will empty the room and leave just us and that individual. We will explain to the individual, if we sign these documents, this is what we're going to be doing. And then we ask that individual to explain it back to us. And if they can tell us, if I sign this document, I'm giving the right for somebody else to sign on my behalf, if they can regurgitate that to us and we see the spark of understanding in their eyes that they get it, then we'll move forward. But if not, we will not, because that's one of the things as a notary that we're attesting to. Not just that they sign the document, but that they understand what they're doing. And so in that situation, if she doesn't understand what she's doing, then you're kind of stuck because you don't have any options left where she can sign to allow anything to happen. And so I am going to put off the answer to what you will have to do until one of the last slides because we will cover that in a moment. But that's not a good situation that you wind up in. And all of these options that we're going through right now, you want to try and choose some of these options before you get into that scenario. Okay?
Thank you.
My pleasure. All right. So here's the challenges about getting a power of attorney for a loved one. A power of attorney does not address in any shape, any way, shape, or form decedent planning. So a lot of people don't realize this when they set up a power of attorney, that your powers cease the second the primary passes. If you sign a check, if you do a debit card transaction, if you do anything on that account after the primary has passed, technically you're operating outside the rights of your power of attorney. And if somebody challenges anything, they would have legal rights against what you've done. Okay. The other thing is that power of attorneys must use their powers for the benefit of primary. And if they do anything on the account that has any murkiness about it, they pull out any money for their own benefit, or if they run their own check through the account or anything like that, again, there could be legal consequences. But I would say power of attorneys, we're starting to get into the point where we're in more elegant solutions to problems. So power of attorney is often the right thing to do. The next solution is helping a loved one create a family trust. Now, I want to get into some details. Some of you may already have trusts. Some of you may be familiar with trusts. Others of you may not. The reason that we're doing this presentation now is because the next presentation is going to be done by somebody who sets these up. And this is, in my opinion, one of the best solutions, okay? Before I define what a trust is, my girlfriend is widowed, and she learned something through that process. She learned that it can be very, very, very difficult to wind down an estate, among other things. But that was the takeaway, financially speaking. And so, of course, she decided to get her own affairs in order for the benefit of her children. So she went to an attorney and she started setting up her own family trust. And as a part of that process, at one point, she needed her father to come in with her to sign some documents. In that meeting, her dad mentioned out loud with the attorney present, well, you know, I just added all my daughters onto the title of my account, or I'm sorry, the title of my house. So if something happens to me, the house is just automatically owned by them, right? And a lot of people do it that way. I just add my daughters to my title of my account. The trust attorney said, oh, you don't want to do that. Stop, stop, stop. Let's convert you to it. We need to do a trust for you too. Now, he's skeptical kind of guy, didn't want to pay the money for a trust. And the attorney said to him, let me put it this way. If you pay the money on the front end to get this trust, here's what you'll be helping your daughters avoid. How long ago did you buy this house? And it had been decades. I think they bought it back in the 80s. And he said, how much did you originally buy it for? I don't remember the number, but it was low. The house now is worth over $500,000. And what this attorney said to him is that if you don't put this in trust and your daughters sell the house after you pass, they have to pay capital gains tax from when you bought it all the way up to what they sell it for. But if you don't, they don't. If you do set it up in trust, they don't. And he did the math. It was something like $60,000 to $70,000 difference that they were going to save by spending a couple $1,000s on the front end. So to my knowledge, they haven't done it yet, but my girlfriend's like, I will pay for it, Dad. Let's just get it set up. So trust can be very, very helpful in avoiding things like tax consequences and the like. Now, what a trust is a trust is a little bit like setting up a business. Okay, so think of it like Microsoft. If Bill Gates dies, Microsoft is still a thing, still a business, right? And they're just going to find the next Bill Gates and pop him into the position, and then somebody new will control the company. Same thing with a trust. It's a perpetual entity. So if the people who set the trust up pass away, then whoever you've written into the trust to be the successor trustees, they just step into the role and they continue the trust forward. They're still able to write checks. The other really cool thing about trusts is you are able to be very particular and very descriptive about exactly what you want to happen. I want to give X amount to this charity. I want to give X amount to my son. And if my son is passed, then I want to go to his heirs. I want X amount to go over here. You can be very specific, and as specific as you want to be, you can detail it all out. And there is a legal obligation to the successor trustees to follow your wishes. And if they don't, those beneficiaries have legal rights. So this is a very elegant solution to the problem. A trust is a legal contract that ensures your assets are managed according to your wishes, of course. Trusts can be tax efficient and may provide tax advantages. Okay, we talked about that. Trusts can adapt to changing circumstances. We talked about that. Trust can allow flexibility and protection that can help plan for contingency plans and provide for a variety of situations. Absolutely. Now, what are the challenges about a trust? And for those of you in the room who have a trust, I want you to pay attention to this part. This last bullet point. The biggest problem I've ever seen with people who've had trusts is they stopped 85% of the way through the process. And honestly, I put the fault of this on either the attorney or communication issues between the attorney and their client. But here's what happens, and I've seen it happen, unfortunately, more than once. Next of kin, who thinks that they're the successor trustee, comes into the bank or credit union and says, I'm here to wind down the accounts. Here's the trust paperwork. I'm successor trustee. And we look up the account, and the account is an individual account with no beneficiaries, or a joint account, or maybe there's a power of attorney on there, but it's not a trust account. We don't go off the trust paperwork. We go off the title of the account. Bank, credit union, the title company. As long as your account is held in trust, then you've done everything you need to do. But what can happen sometimes is you go through the process, you go see the attorney, you get all the paperwork, you get your little binder and you walk, well, your big binder, and you walk out with all your stuff. You have to take that to the bank. That's your next stop. You give it to them, they change the title on the account. You have to do that for every bank, every financial institution that you want that money to be in trust for. And if you don't do that, whatever accounts you have not done it for are not in trust and not protected by the trust. Okay. So that is probably the biggest problem that I see that people run into when trusts are involved, because they haven't done all of the steps. Now, just because the account might not be in trust doesn't mean you're not protected. Sometimes what people will choose to do is add the trust as the beneficiary on the account instead of actually changing the title on the account. It's an option. I don't like the option, but it's an option. Basically, if something then happens to you, they don't get the option to continue the account forward. They have to close the account. They get a check payable to the trust, and then they have to take that trust paperwork and open a new account. So that's the way they would move forward if they were to go that route. There are other things about trusts. They're not easy to change. So if for some reason, let's say you're in a situation where you've got your trust all figured out, and then you're like, you know what? I want a power of attorney on this account with me. I want a signer that, I haven't written it into the trust yet, but practically speaking, now that I want to make this change. Well, you have to go to the attorney, and the attorney has to prepare it and write an amendment to the trust allowing that change to be made. So it's not just a simple conversation with you in the bank anymore. Yeah. So I recommend this highly. Out of all of the problems I've seen over the years, trust accounts are the least problematic that I've seen. And I shared with you the only problems that I've run into with those. So if you are in a situation where I'd say you'd probably want to start thinking about it around the $50,000 on deposit in a financial institution, mark, or more. And if you have less than that, some of these other solutions are probably fine. But if you have more than that, I highly recommend a family trust. There is something, let's say that you are in a situation where an account, their primary is passed and it's way less than that, and there's like nothing set up, it's just individual. Family members, there is a process called a small estate affidavit. What's the dollar amount on that? 100. Yeah, and it's a weird number. It's like 153 or something like that. So it's around $160,000, but it's the value of your estate, not just the value of the accounts there at the bank or credit union. So if the total value of the estate is less than that 150 something thousand dollar number, you can file paperwork and wait 40 days after the date of passing and claim the account that way. So like I said, for smaller accounts, I don't want to make it sound like this trust is going to be the right solution if you have like, a small account. But if you do have a larger account, these can be very effective. All right. Now we're back to that situation we heard about a minute ago, where the spouse is no longer able to handle their own finances and is now individual on the account. Well, If you're in a situation where somebody is not able to handle their own finances and there's no plan already in place, then the really only thing that you can do is a guardianship. And a guardianship is done through the courts. It is not an easy process. And oftentimes you're going to need legal assistance to get through the process. If you want to try and figure it out yourself, you can. I would be intimidated to do so. But basically, what a guardianship is you go in front of a judge, you explain the situation, and you file paperwork proving that this individual can no longer handle their own finances. And then the courts will grant you two different types of guardianships. There is a limited conservatorship where you only get certain functions, or a general conservatorship where you would get all legal and financial functions. The next step after you do that is to go to the bank or credit union with your legal paperwork and open a guardianship account. And then we would close all of the individual accounts on behalf of that person and move the money into that guardianship account. And it's court ordered. And so if there are any changes, let's say you get tired of being their guardian and you want somebody else to take over that role, right back to court. It is not an easy process. It is not a quick process. It is not a painless process. I would never wish this on anybody. But if you don't have a plan, this is what happens. The downside of getting that conservatorship is, of course, difficult to get and expensive. Also, the court system will meticulously monitor the system to make sure that you're not misusing your powers. Basically, they audit the accounts and they make sure that you're using it for the benefit of the primary. And just like I was saying earlier, this is a worst case scenario. This is something that you accidentally let happen to you if you don't plan on the front end. So it is way better to proactively work with professionals and come up with a different plan than to get in a situation where you need one of these. And then lastly is probate, which is very similar to the conservatorship situation, except with the conservatorship situation, the primary is still alive. In the probate situation, it's the same process, but the primary has passed. So in this situation, it is a structured legal process that allows the court to oversee the distribution of your assets to make sure that it's done fairly. It will also, it does provide protection to all involved parties. So it does make sure that things are at least fair from the judge's perspective. And any kind of disputes are handled as a part of that process. And so generally when probate is wound down, all disputes have been handled. Of course, it is very time consuming, very complex, high costs, high fees, and a lack of privacy, since everything is a public document and it all gets filed. So if for that reason alone, you want to avoid probates. So with that being said, I wanted to open us up for some questions and some discussion, because I know I've gone over a lot of concepts and I wanted to hear what you guys may have run into, whether you guys have any questions about the process. Again, I worked for 2 banks and a credit union. So because I've worked for 2 banks and a credit union, even if you aren't with Noble Credit Union, if you have questions about it, I would love to address them. Sure.
Power of attorney, like when we set up a trust, is it only how does that come into effect? Like there's us in the trust and then our kids as beneficiaries. If the power of attorney come in for either of us, neither of us, both of us, like if one passed and one didn't, it was the person with the power of attorney still have the power of attorney in case that one left is incapacitated, like you just mentioned, or something?
Right. So that is with
trust. Can you repeat the question, please?
Yeah, absolutely. She was asking how powers of attorneys and trusts interact with one another. So basically, if you have two people who have a trust account and they wanted to set up power of attorneys, what are all the different ways that you could run into issues with that? What I will tell you is that power of attorneys and trusts are required to point at one another. And what that means is that you can't, without an amendment, you can't set up a trust and then later set up a power of attorney. Typically, they're done at the exact same time, or again with an amendment saying that, hey, The trust allows power of attorneys to be set up, and the power of attorney says you receive power to sign on behalf of the trust. Once they're set up, they are set up in a way that will allow the person to sign on behalf of the trust as long as one of the people are still alive. Okay. They're not required to be the successor trustees. So remember, the successor trustees are the people that take over if the trustees pass. So it doesn't have to be the same person, but oftentimes they are. What that allows you to do is you haven't listed them as full trustee yet, but they still have signing rights to start signing now. And then if something happens to you, then they maintain those signing rights with just a different title. So we do see some of that. It's not common, but it's something that people do sometimes. So yeah. You said there were 2 questions. Is that both of them?
The other one I'll just ask the next time.
Oh, okay. All right. Yes.
If a trust is not drawn up, a durable power of attorney, would that eliminate the need for conservatorship or guardianship?
Yes.
Like
Yes. Depends.
durable.
Durable, yes. However, so that everybody knows, as far as power of attorneys are concerned, there are a variety of ways to set them up. Durable power of attorney typically means that you've gone out and you've spent the money to get a power of attorney that is to be used multiple places. But oftentimes you can go into a bank or a credit union and use their power of attorney form to set up a power of attorney that works only at that bank or credit union. Okay. So if you've done that, then that person doesn't have any signing rights anywhere outside of that bank or credit union. It is only for that account. So in that case, you've avoided the need to go to a lawyer, but they don't have any rights outside of that bank or credit union. And so you wouldn't be able to use that power of attorney to avoid things like a conservatorship. Now, you would still have access to that account, but you couldn't do anything else on behalf of that person. But if you have a durable power of attorney that has been set up and the person is still alive, then yes, that would allow you to sign on their behalf for just about anything except health stuff. You need a health directive in order to do that.
Brokerage, investments, and you cover any other institutions.
So with the power of attorney, within the document, generally speaking, there is a list of what it covers. And as long as you've actually initialed next to the all of the above, or you've initialed next to each thing that you're getting them power to do, then you have those rights. If anything is not checked, then you wouldn't have those specific rights. So absolutely. Great question.
How hard is it if you have a trust and you have a power of attorney and God forbid the power of attorney passes? How hard is it gonna be that since you've already done this trust and have it, how hard is it gonna be to put someone else in there? You have to go to court to do this? Or?
You don't have to go to court. It depends on if you've anticipated it. So a lot of times when you go to an attorney to set up a trust, they are going to ask you questions about what if this happens, what do you want to happen then? So oftentimes it's written into the trust, hey, I'm going to grant power of attorney to this person, and if something happens to that person, then I'm going to grant successor power of attorney to this other, you can chain of events happen, set it up as a plan. But if you haven't done that, then it would take an amendment, which is just going back to the attorney and just writing a little add-on. Of course, they're going to charge you for it, but it wouldn't be as much as setting the trust up in the first place. It would just be a quick little amendment to it. But no, it does not need to go to the court system. It would need to be put on file with wherever they're going to be using it. So you would then go to each bank that you've got the trust set up at, and you would inform them of the change and give them the new paperwork, and then they would make the change on the account name.
So if you had one person and you went ahead and added the other when you made the trust, when I go to that credit union and say, okay, here's all my paperwork. So if something happens to that first one, it automatically kick on that second one.
So yeah, what you'll do is you'll fill out that paperwork, because the banks have their own paperwork. They are not going to want copies of your whole trust, and the reason is that they don't want to know that this American Red Cross is going to get this, and they don't want to know anything that you're doing with the money. They just want to know what's your succession plan. who's in charge now? If something happens to you guys, who's in charge next? Who can sign when? So they have their own paperwork called the memorandum of trust that they would have you fill out. And so you would put it all in there. And oftentimes, if you need help with the memorandum of trust, you could bring that in with you when you set the trust up to your attorney, and they should be able to help you fill it out. In the banks and credit unions, we'll generally define terms, but we can't help you fill it out because that would be giving you legal advice. And so because of that, we're kind of, we can tell you what a trustor is, but we can't look at your trust documents and say, there's your trustor. So, but yeah, generally speaking, you fill out exactly what that succession plan should look like on that paperwork. And then you really only need to file like full paperwork if anything strange happens. So if, people pass out of order or, that kind of thing, then we might have to look at the trust document again. So.
We set up our account at the credit union years and years and years and years and years ago. One's a trust, which I assume because we had to open it as a trust that they have all that paperwork, but I'll find out. How do we find out what we've got? Like, I don't even know if there's beneficiaries on our checking account. Our kids are children when we
great question. I'm so glad you asked that question because that is reminding me that there's something else that I wanted to bring up.
Can you repeat the question, please?
Yeah, the question was, how do you find out how your accounts are titled if you opened them years and years and years ago? Do you just walk in and ask? So here's my answer. I don't recommend you just walk in and ask. I recommend you walk in. Well, you're with Noble. I recommend you grab her business card. I brought her on purpose. She's from our Cedar team. Yeah. So she is one of the best people in the credit union at trusts. The reason I bring that up is because you can't assume that the person who's helping you at the bank or credit union is going to have the knowledge to be able to handle trusts. What I recommend is that you walk in and you do the scan and you look for a little bit of gray hair. There you go. You got yours dyed. But you look for somebody that looks like they've made it a career, and you don't necessarily allow yourself to be helped by the 25-year-old that just graduated. And there's nothing against the 25-year-old that just graduated, but these concepts are something that you don't learn. You learn these in time, and so if you need help trying to figure out how to title your accounts, finding that person who has dealt with trusts over time and who is good at it, and Noble has a few. Yeah, and so you just walk in and see somebody at a desk generally. And yeah, you're going to want to say, all right, each one of my accounts, how are they set up? Do I have beneficiaries? Let me look at the names of those beneficiaries. Are they still the people that should be my beneficiaries? Did somebody's name change? Did somebody's address change? We don't typically, at any financial institution I've been a part of, we don't keep social information on file for these people. It's just name, but sometimes people get married or, whatnot, and you can update that information. Updating your signature card is never a bad thing. All three places I've worked, anytime your signature changes, they would be fine to have you sign a new signature card. So if you just walk in and say, how's my title set up? I want to check who my beneficiaries are. I want to see, what's in trust, what's not. Is that right? And then let me sign it. They'd be happy, generally speaking, to do that. And if you're not with Noble, check with your own financial institution and find somebody there that you feel comfortable with their advice, and they should be able to help you. Yes.
The bank never asked for them. They
Okay.
put it on. They don't need anything with it because if something happens, the person would just bring in a copy of the paper and that's it.
Yes. So all three places I've worked at needed something, but we don't always. Yeah, like the cover page, just to get the title right. Yeah, that's pretty standard. The first place I worked, we took a photocopy of the title page, the page that showed who the trustees and trustors were, and then the signature page, the last page, and that's all we kept. But that's not that was their procedures. Every place does it differently, and honestly, as long as the title is on the account, your account is fine. But you said one other thing, that it's a widely held misconception, that I'm glad you said it because I want to bring it up. You said will and trust. There are people that are out there who have set up a will and they feel like that will is providing them some kind of protection. It is not. From the bank standpoint, we cannot take a will, and a will not keep you from going through the probate process. The only difference is the probate process will see the will and try to honor the will. But you still have to go in front of a judge, present the will, and go through that whole process. So a will is fine, but it's not going to give you the same protection on the title of your account that a trust would. So if you have a will, maybe get the rest of it. Get a trust too. Any other questions?
Make a statement. We've been through, mom passed away and had the trust, everything was going good, but there was an account we didn't know about. And it had to go through probate, and it took forever, and the attorney charged a big fee to handle it.
Yes, sir.
So you gotta make sure everything's.
Yeah.
If it counts outside the trust, if you can help it.
Right, yeah, we didn't know this.
Yeah.
Totally a surprise, and probate was a surprise also.
Yeah, and that sounds very unpleasant to go through. I'll add to it that there might be times where you might want an account outside of the trust, but I do it on purpose, not on accident. And here's what I mean by that. There is a gap in time that I casually call the black hole. And that gap in time is the date of passing is when it starts, and the end is when Fresno County or whatever county finally gets around to issuing a death certificate. Between those two dates, you probably won't have what you need to access anything because the paperwork hasn't been issued yet. Now, normally those two dates are not that far apart, but during COVID, it got to the point that those were months apart in some cases. And so one solution that some people have used to get around that and to maintain that access is on their main bill paying account, they would keep that account not in trust. And instead, they would use one of these other solutions. Oftentimes what they do is they would add a power of attorney, the same person, power of attorney and beneficiary. And if the same person is power of attorney and beneficiary, it doesn't matter if the primary is alive or passed, that person still has signing rights, right? So the banks or credit unions wouldn't take away, they wouldn't freeze the account because obviously that person should be able to access the money. And then what they did was that they kept enough money in there for a couple months worth of expenses. So like I said, I would never do it on accident, but on purpose, there might be a reason to keep something outside of trust just to give some liquidity and help people make those financial decisions, pay for, funeral expenses and whatnot. What you would do is you would go in and see somebody at the bank and you would say, I want this person to be my beneficiary, and I also want the same person to be my power of attorney. So it's an and situation. Yeah. So you would, if you were going to do that, you'd want to sit with somebody at a desk, and but yeah, it's this normal signature card that we would use. And there's a power of attorney addendum that we would add to it. So yeah, that's a solution that we've done for some people in some circumstances. Not always necessary, but if you're trying to be thorough, then that would be a good thing to do. Any other questions?
Feedback like that, so your non-hire money, if you have that with us, or you have like the investment account, we have what's called TOD, transfer on debt. Not for your IRAs, but for like this kind of brokerage account, so you just want to make sure your advisors are pretty much so it's canceled. If you're okay, but just in case, let's make sure you have the TOD on it. It's what TOD. I didn't know.
Yeah, and you actually bring up a really good point. IRAs cannot be put in trust because IRAs are individual retirement accounts. They cannot be owned by anybody other than an individual. Also, you can't just put your trust on as beneficiary if your spouse is still alive, because your spouse is required to be the beneficiary, or they would have to sign off on their benefits. So oftentimes those are handled differently. They're also handled differently from like NCUA or FDIC coverage as well, because there's really not a lot of, you don't have a lot of choice around what you can do. However, if, especially as a spouse, if you're willing to sign off on it, I do believe you can put a trust on as a beneficiary. Is that?
Yeah.
Yes, you can.
Yes.
Yeah. So as long as you're putting them as a beneficiary, you can do that on a retirement account. Anything else?
And same with 29 plans, 529 plans.
I believe so. Yes. I'm not a financial advisor, but I believe the 529 plans allow that as well. Yes.
Okay. And did you already mention what type of trusts you're talking about? You say trust, and then did you
Yeah.
mention, like, are they revocable trusts or irrevocable or living or?
So the generic trust that we see is living, loving, revocable trust, but that is just the standard. That's the normal version of trust, the most common version of trust. The only difference between revocable and irrevocable just means that you can't change it once you've created it. Oftentimes those are done as a part of a divorce proceeding or something that you want to make sure that, like, hey, no one can touch this. There's no legal rights to make changes after it's created. So oftentimes, the irrevocables are just rare by definition. We don't, most of what we see are living, loving, revocable trusts. I know there's all sorts of other flavors of trusts, but most of those trusts have to do with businesses. And I am not an expert on those. Noble does not do business accounts. And I did not do those when I worked for my previous financial institution. So I'm specifically talking about living, loving, revocable trusts when I say that. Thank you for the question.
Awesome. Yeah. Thank you for answering it.
Right, and for that question, so next month, of course, on March 12th, we'll be talking about all that, or not us, but Paul Frank will be talking about all that. So this is a great prelude to that.
Absolutely. So
You did a great job.
we wanted to give you guys the information now so you can chew on it for a little while. And then in March, you can make some changes if you need to.
Awesome.
All right. Well, thank you guys. That's the
Give them
presentation.
my gift or the change, or no,
But please make sure you
And
send us
we'll hang
this
out for a little
recording.
bit. So if any of you have individual questions that you know, a little too private to handle in a group setting, feel free to stop by the table. We'll be ready to.
that was just second part of the presentation, this mask from our kicks out, so we're gonna talk, what, 45 minutes you got still?
From Roseville.
Hey, this kid, I'm just. You wanna drink or? Thank you for joining us on your Zoom call. We appreciate you. Any feedback you have, you can send us an email. That'd be awesome. Thank you. Thank you.
All right. Thank you so much.
Oh, thank you.
Absolutely. I tried hard. Of course.